Amendment to H.R. 3309 as amended, offered by Ms. Eshoo of California.
And the amendment will be considered as read, and the gentlelady is recognized for 5 minutes in support of her amendment.
Thank you, Mr. Chairman. I'm offering this amendment today to secure disclosure for the voting public. In an election season in which voters will be are being deluged with hundreds of millions of dollars in political ads, many of them aired under misleading names, voters are clamoring for transparency. My amendment is very simple, and it adheres to the same principles many of my colleagues have supported before. If an organization buys political advertising time on television, including cable, satellite, broadcast, as well as radio, it would be required to disclose its large donors, those who give $10,000 or more to air the ad. It's a fair amendment because it applies across all mediums. Whomever pays more than $10,000 to air a political ad, their name will be disclosed in the public inspection file. Our constituents, the voters, are smart, but they also have a right to know, and with this knowledge, they can draw their own conclusions. I believe sunlight is the best disinfectant, and I ask my colleagues to join me in supporting this common sense and important transparency measure. And I don't know if anyone would like to speak on this. I'd be happy to yield time on my side. I'd be happy to yield to Mr. Dingell. Gene?
I'd like to thank the gentlelady for yielding, and I support rigorous reporting requirements for advertising. These are important to increase the transparency in our democracy. However, this language in the bill, I hope, is interpreted reasonably unless we adopt this amendment by the FCC. Broadcasters should not be held liable with their license in balance over issues they have no control over. If a super PAC, for example, misrepresents facts to a broadcaster and that broadcaster files with the FCC, that should not penalize the broadcaster because super PAC should be responsible for the false information. Broadcasters can't be the cop on the beat, and we have to, FCC or the FEC, to do that job. And with that, I'd be glad that my colleagues has the amendment. I look forward to supporting it.
Thank you, and I appreciate your comments. Is there anyone else that would like to speak? Be happy to yield time to. If not, I'll yield back.
Gentlelady yields back. Chair would recognize the gentleman from Oregon.
I thank the gentleman. I'm going to rise in opposition to this amendment. I want to clarify one thing, too. I was just reading through the amendment because in your remarks you said it would apply to radio broadcasters as well. I don't see that in here. It appears to only be video. Is that correct or not?
Well, responding to the gentleman, it applies to all television.
Oh, yeah, I'm talking about radio.
All broadcast licenses.
So all broadcast
television, including cable, satellite, broadcast, as well as radio. So it doesn't single any group out. It just applies across the board, which I think the voting public deserves.
I appreciate that clarification. I guess while I'm not opposed to disclosure, I'm not sure I am sure this is not the proper place to do this. We're talking about how we reform the Federal Communications Commission's processes. I think this is worthy of discussion in another place and another time, but I don't think this is that place or time. Obviously, there are lots of questions about Citizens United and super PACs and all of that and how they disclose. I think this does put the burden back on the broadcaster. The broadcaster, in these cases, is on the line anyway, as it is, for the content of the message. Unlike one of us buying time in a broadcast environment, there the broadcaster is not on the line for the content of the message. We are. Third-party expenditures, they share a responsibility to make sure that it's not knowingly false. when it's put out there. And so they have a lot more flexibility. I don't know how someone picks just a arbitrary $10,000 amount or more. I know you got to pick something somewhere, but I think this whole issue needs to be dealt with in a more comprehensive manner in a different venue. And so I would oppose this amendment on this basis. Sure, of course.
I just want to observe that the parliamentarian found the amendment to be germane.
Certainly,
so
I understand that.
It does fit with what we're doing, and I was prepared to withdraw if it was not found to be in order. So
certainly. Reclaiming my time, I was not alleging that it was not germane. There are lots of things that could be germane to the Communications Act and the underlying law, but don't really pertain to the discussion we're having here about FCC process reform. This more falls in the campaign process reform, and so I would oppose and yield back my time.
Will the gentleman yield?
Gentleman yielded back.
I yielded back. Sorry.
Gentleman yielded back. Given a unanimous consent to reclaim your minute.
I'd reclaim the minute and yield to my colleague from Illinois if the committee's okay with it.
Well, thank you. And I think just to add on to what you're saying, I think, again, the purpose of this bill is not to really get into campaign finance law and details. And, I mean, there's a time and a place for that, and I think it may be a discussion that's worthy of having. But the purpose of this is just simply to say, look, the current chairman has really put a lot of process into place, which I think is good. Really opens up the commission, really is getting people engaged and understanding of what's happening. But we just want to take some of the good things that he's already done, expand upon it, and open up the process of the commission. It's just basically giving the public the ability to take a look inside their government to see what's going on, to ensure that there's rules in place. And again, it's really taking into account a lot of what's been happening now. So again, when it comes to, talking about campaign finance reform and all this kind of stuff, that's a discussion that's worthy of having eventually. But I think that's not necessarily what this bill intends to do, as we just want to open up the process. And I thank you, and I yield back.
Does the gentleman yield back his time? Gentleman yields back. The chair would recognize the gentleman from California for 5 minutes.
Mr. Chairman, we've been told this bill is about openness, transparency. Let the public know what's going on. This amendment furthers that purpose. Today, the FCC requires broadcasters, cable providers, and satellite providers to maintain and make available for public inspection requests to purchase airtime related to political advertising. Right now, the FCC does that. That's so the public will know who is going to buy the time. But there's no requirement to disclose who actually pays for the advertisement. The public ought to know about that too. And this amendment would accomplish that goal. Rather, the file simply needs to contain now the name of the person or entity requesting airtime. But it's easy to see how viewers might be confused. Who's actually financing the advertisements they see and hear every day? Mild-sounding names like taxpayers against something or other can hide the fact that the advertisement is actually being funded by a corporation or a limited group of wealthy individuals who may well have a vested economic interest. But the public doesn't know that. In California, we have a lot of ballot proposals. And when the public finds out that the oil companies are sponsoring something that they say is good for the environment, that has a psychological effect. Disclosure is important. Openness and transparency. We've been told that's what this bill is all about. Political ads can have a great impact on the outcome of an election because the broadcast medium has the ability to reach vast numbers of citizens. A recent study revealed that as of this January, 95% of spending during the 2012 election cycle was backed by outside groups as opposed to candidates and political parties. As a result of the 2010 Supreme Court decision in Citizens United versus the FEC, we've exacerbated the problems of insufficient disclosure in political advertising. This amendment simply recognizes the incredible impact of such advertising and that it can have on the outcome of an election. And it does not increase the burden on broadcasters or cable providers and satellite providers in maintaining public inspection files related to political advertisements, since they're already required to do this, keep a record of requests to purchase airtime and on file at their stations. So it's, I think it's a well-crafted, well-worth amendment. This is the time for this amendment. This is what this bill is all about. Let's don't take something and say, this is a good idea, but it ought to be considered another time, another place. This is the time and place where we're being told legislation to provide transparency and openness is before us, and this is the time and place for us to adopt this amendment. I urge my colleagues to vote for the SU amendment.
Gentleman yields back his time. The gentleman from Texas is recognized, Mr. Gonzalez.
Thank you very much, Mr. Chairman. I'll be brief. To those individuals, my colleagues that express an interest in maybe looking at this issue in broader terms, I would welcome their co-sponsorship of H.R. 4010, which is the Disclose Act. But this is a sincere and could be a very effective way of taking one step in the right direction. This is an opportunity. It is about transparency, and it's not really placing any additional burden on our broadcasters. The truth of the matter is that the great bulk of the money is being spent via these individuals that own the stations, running the ads, and so on, and it would be appropriate that we'd have this collection of information, again, so that the voter is knowledgeable, we know who is behind the advertising, something that we don't have presently. And I'm hoping that we will be able to address, as I've said, on a wider scale. Until that day, we have an opportunity today to do something that will educate the voter. And I would yield back at this time, and I support, of course, the amendment.
Will the gentleman yield the gentleman from Michigan, Mr. Dingell?
I will.
Gentleman from Michigan is recognized for 5 minutes.
I thank you, Mr. Chairman. Again, I express my great affection for the chairman of the subcommittee and the chairman of the full committee, and I want to make clear I support the amendment. But I think we all need to know a little more and to understand how this is going to impact what this bill is going to do. Now, the committee's been charging around happily with a bucket on its head with no idea of what we're doing or what will be the consequences of the legislation. And we've already amended, I think, the Federal Communications Act, the Administrative Procedure Act, and I'm not quite clear how many others, but probably the Freedom of Information Act and a number of other statutes that will relate to how the business of the nation and the business of the FCC is being conducted. And I don't think there's anybody in this room, and certainly nobody on the staff, who knows what this is all going to do. In any event, having said that, I think we desperately need openness here. We've got a bunch of billionaires and millionaires who are pouring millions of dollars into the elections of this country under these super PACs, with nobody having the vaguest idea of who they are, what they're up to, what they want, or what will be the consequences of it. But they're literally able to secretly buy the U.S. government and buy the next election. And we certainly have to find that. Now, one of the questions we have is, are we going to hang criminals with this or innocent men? The history of election law is that the criminals get away and the innocent men go to jail. This is hardly a comforting thought to me or to anybody who studies our election system. In any event, having said that, Mr. Chairman, I am asking the attention of both the chairman of the subcommittee and the chairman of the full committee. I'm hoping that this bill is going to be vetted with all of the stakeholders, and we'll have some appreciation of what the different provisions of the legislation mean, most specifically those which are relating to liability in the case of noncompliance with the disclosure requirements. Do you think that the chairman of the subcommittee, Mr. Chairman, or the chairman of the full committee can comfort me by telling me that we're going to go into these questions to find out what assurances we have with regard to potential liabilities in the case of noncompliance with the disclosure requirements? I yield either to the chairman of the subcommittee or the chairman of the full committee.
I'd be happy to try and take the question and get you an answer.
I will yield to the gentleman with enormous respect.
And I return that. I get, is the question regarding this amendment and the liability that might ensue from it?
Pardon? We're discussing here the amendment, I tell my good friend, and in
so,
other words, I want to know what is going to be the liability of persons involved here with non-compliance with the disclosure amendments. Will we have the staff look into it so we have some appreciation of what will be the liabilities and what will be the risks and the dangers to persons who might be involved, probably innocently, but might be headed on a quick trip to the jailhouse?
I think the gentleman raises really significant questions because this issue has not been vetted along the way in the subcommittee or in any of the hearings. It was not an issue that had been brought up and discussed. We had a number of hearings. We've had a lot of discussions. This is kind of new. I was wondering myself what the definition of political programming is on line 7, because I'm curious who all is captured by this, and maybe the council. I don't know if council can speak specifically to the definition of political programming as it's found on line 7, because that would be a question, Mr. Chairman Emeritus, that would be in play here. What all does the broadcaster have to look at? What is the term political programming? Who all does that capture? How do they determine that? That may be defined in statute. I just don't know. That's why I don't think, frankly, this is the right place. And I appreciate my colleague, Mr. Waxman from California, now advocating for this amendment in the notion this bill will actually pass and become law, because earlier he wasn't quite so sure that was going to happen. But I would yield to council if we can find even a definition, because I think that is one of those issues. It's about the liability. It's about he yielded to me, I believe.
I was happy to yield to my good friend.
Yeah, those are the legitimate questions. I would yield back.
Does the gentlewoman wish to yield?
Thank you, Mr. Dingell. I think it's important to establish that the amendment does not bring the burden to any of the broadcasters. It's the responsibility of those requesting the airtime, the broadcast time, the satellite time, the cable time, the radio time. It's up to them to place in the file the information that is part of the amendment. So the burden does not fall to any of the broadcasters. And I thank you for yielding.
Would the gentleman yield? Because
my time is run out, but if I could have, I ask you to consent, I have 2 additional minutes, and I'll be happy.
I appreciate that, because then, first of all, I think we have to ask the question political programming, because the broadcaster is responsible for getting this certification from each entity sponsoring political programming. So we need to know how that's defined in statute, and it may be. The second is kind of an interesting point, too, on line 10, as I read this for the first time, that that they require this certification from an entity finding out who contributed $10,000 or more to such an entity during the 2-year period preceding the request for broadcast time. The reason I raise that is it would be real easy to get around this particular amendment, because an entity could put in the request for time as the committee for you name it, buy the time, and then get the donation in. So, because this says that they want to know the donors in the past 2 years. Well, those donors may not have anything to do with the current buy. Because I was in the business. We'd get requests from ad agencies for time, and they may or may not act on that request. This is predicated on a request for time. And so, therefore, you could have a request for time, and it may not reflect who's actually paying for it if you're reaching back 2 years looking at big donors. Because you could have a different entity. Heck, I'd just create a different entity each time and get right around this. So I don't think this serves the purpose you're trying to get to.
If the gentleman would permit, the purpose of my comments were not to discuss in detail what's going on here, because I simply do not, in fact, know. But it is to say that if we're going to proceed on this, we ought to, at least as we go forward, have the staff to look at us and tell us what it means, what the perils are, and whether or not we ought, in fact, to continue, or whether this ought to be amended or adjusted or addressed in
Mr.
some
Dingell, would you yield
or,
in your
or otherwise fashioned.
Mr. Dingle?
And
Would you yield?
I'll yield to the gentleman, yes.
I thank you. If we're going to look, I think we ought to accept this amendment because we're going to have to look at it and refine it and figure out some of these details. That's not a reason to be against it. But the whole bill is going to have to be evaluated, carefully revised, and
Well, if the gentleman
compromised if
permit,
it's
I'm
going
not
to become
opposed
law.
to the amendment. I just want to make sure we look
Right.
at it.
Good point.
And that the leadership of the committee sees we go into it in order to know what we're doing and to make sure that there are not some very red faces on the committee.
Gentleman's time has expired.
Mr. Chairman.
I think we're ready to vote on this.
Mr. Chairman, I know you want to vote, but I want to. I don't want to pile on. I just want to speak against the amendment and understand this path that we're going down to. First of all, the First Amendment says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech. Now the question, this is a great debate for the Judiciary Committee, the constitutional prerogatives. Is disclosure abridging the freedom of speech? I think the Supreme Court has ruled that money is speech in current rulings. Does political programming, who's going to define political programming? And now how is that part of this whole debate we're having on the free exercise of religion in other venues in the healthcare debate? And is the free exercise of religion now going to be thrown into political speech? I understand the concern. I've wrestled with campaign finance laws. We've all been attacked by unnamed individuals. I'm coming down on the position now that let it all come. I'll sort it out. It's free speech, First Amendment principles, and that's kind of where I'm standing on. So I definitely don't think this is the right.
Gentleman yield.
Gentlemen, yield.
Well, let me finish. I don't think this is the right venue, first of all, because if you're going to do campaign finance law and you're going to fight the judiciary constitutional First Amendment, that's a Judiciary Committee provision. And then, so I'm not comfortable with the amendment. I want to first yield to my colleague from Oregon, Mr. Walden.
Well, I appreciate the gentleman yielding, and I'll try and get through this. You could drive a 527 freight truck through this, because all you have to do is create a new sub-entity, request the time. It has no donors from the prior 2 years. And then you buy the time, you reserve the time, and then you go get the donors, and you repeat the process. So I understand what you're trying to get at, and I think this is an issue that, as a Congress, we need to look at, is how we get more openness. I just think the FCC and the broadcaster should be the one doing this. I think perhaps the FEC or someone else should, but even then, this doesn't get at what you're trying to do, because all you do is create a new committee for the preservation of whatever or the opposition to whatever. It has no prior donors because it's new. It's simple as filing, and I yield back.
Gentlemen, yield.
Gentlemen, yield.
Gentlemen, yield.
Mr. Waxman, can I just get Mr. Gonzalez first, and then I'll...
Well, real quick on political speech, freedom of speech, we already know with Citizens United, the Supreme Court said, look, disclosure, timely disclosure and such is something that could be contemplated given when they exercise such freedom of speech, either individually, corporations, entities, super PACs, whatever we want to call them. So I don't think disclosure it tramples or in any way threatens any of the constitutional protections we have. Secondly, as far as how some individuals or entities may be able to circumvent the intent of this law, that's always going to happen out there. But that is not a reason why we shouldn't be doing that which we can do at this point in time, given that we probably aren't going to be doing anything that is more expansive. This is a step in the right direction, so I think we can respond to those concerns, and I yield back, and I thank...
Reclaiming my time, Mr. Waxman.
Thank you very much for yielding to me. I agree with what Mr. Gonzalez just said on the constitutional question. I would observe that some of our Republican colleagues who talked about this amendment are finding it hard, but they're straining to look for a reason to be against it. And I think that we ought to be for it, and if there are little provisions that need to be changed, we could change them as part of the bill. The bill in its present form is not going to be law. It micromanages the FCC in a way that is not going to be acceptable, in my view, to others that are going to have to pass on this legislation in the Senate and the President.
And if
so
I
I would say let's put this in the bill and let's review the whole issue. But don't exclude this from the bill, because I think it makes this a much better bill for openness and disclosure.
Reclaiming my time and yielding the balance to my colleague from Tennessee.
I thank the gentleman for yielding, and I will just note with my colleagues that I am thrilled to see their interest in transparency and who is giving to different organizations. And I would like to remind you all that about 9 months ago I asked an organization that came before us for a list of their contributors. They said they would be happy to comply, and we at the subcommittee are still waiting to get a list of those donors and participants with Free Press. With that, I yield back.
Time has expired. I think we're ready to vote on this amendment. We'll ask for a roll call vote. All those in favor will say aye. All those opposed say no. The clerk will call the roll.
Mr. Barton. Mr. Barton votes no. Mr. Stearns. Mr. Whitfield. Mr. Shimkus. Mr. Shimkus votes no. Mr. Pitts. Mr. Pitts votes no. Mrs. Bono-Mack. Mrs. Bono-Mack votes no. Mr. Walden. Mr. Walden votes no. Mr. Terry. Mr. Rogers. Mr. Rogers votes no. Mrs. Myrick. Mrs. Myrick votes no. Mr. Sullivan. Mr. Murphy. Mr. Murphy votes no. Mr. Burgess. Mrs. Blackburn. Mrs. Blackburn votes no. Mr. Bilbray. Mr. Bass. Mr. Bass votes no. Mr. Gingrey. Mr. Gingrey votes no. Mr. Scalise. Mr. Scalise votes no. Mr. Latta. Mr. Latta votes no. Mrs. McMorris Rogers. Mr. Harper. Mr. Harper votes no. Mr. Lance. Mr. Lance votes no. Mr. Cassidy. Mr. Cassidy votes no. Mr. Guthrie. Mr. Guthrie votes no. Mr. Olson. Mr. Olson votes no. Mr. McKinley. Mr. McKinley votes no. Mr. Gardner. Mr. Gardner votes no. Mr. Pompeo. Mr. Pompeo votes no. Mr. Kinzinger. Mr. Kinzinger votes no. Mr. Griffith. Mr. Griffith votes no. Mr. Waxman. Mr. Waxman votes aye. Mr. Dingle. Mr. Dingle votes aye. Mr. Markey. Mr. Towns. Mr. Pallone. Mr. Rush. Ms. Eshoo. Ms. Eshoo votes aye. Mr. Engel. Mr. Engel votes aye. Mr. Green. Mr. Green votes aye. Ms. DeGette. Ms. DeGette votes aye. Mrs. Capps. Mrs. Capps votes aye. Mr. Doyle. Mr. Doyle votes aye. Ms. Schakowsky. Ms. Schakowsky votes aye. Mr. Gonzalez. Mr. Gonzalez votes aye. Mr. Inslee. Mr. Inslee votes aye. Ms. Baldwin. Mr. Ross. Mr. Matheson. Mr. Matheson votes aye. Mr. Butterfield. Mr. Butterfield votes aye. Mr. Barrow. Mr. Barrow votes no. Ms. Matsui. Ms. Matsui votes aye. Mrs. Christensen. Mrs. Christensen votes aye. Ms. Castor. Ms. Castor votes aye. Chairman Upton. Chairman Upton votes no. Mr. Stearns votes no. Mr. Whitfield votes no.
Mr. Burgess.
Mr. Burgess votes no.
Mr. Terry.
Mr. Terry votes no.
Mr. Bilbray.
Mr. Bilbray votes no.
Are there other members wishing to cast a vote? Seeing none, the clerk will report the tally.
Mr. Chairman, on that vote, there were 16 ayes, 30 nays.
16 ayes, 30 nays. The amendment is not agreed to.